So I'd like to begin by telling you a bit about how things came to be. And, well, a political solution that works for all stakeholders is preferable to mounting a charter challenge. But the Canadian federal government has not seen fit to negotiate with sex workers in good faith ever. Though there was a short-lived glimmer of hope during Pierre Trudeau's tenure as Prime Minister. Pierre Trudeau partly decriminalized gay and lesbian sex when he was Justice Minister in the Pearson government. He used the 1957 Wolfenden report from the UK as his reasoning for doing so. Trudeau Sr. rewrote the gross indecency law, decriminalizing gay and lesbian sex if it happened in private between two consenting adults of at least 21 years of age with no one else present. There were still many laws on the books that discriminated against gay and lesbians, and in policies such as labor rights, spousal benefits, and same-sex marriage, to name a few. But that little change was in fact a big change that allowed the road to full decriminalization to be built. What many people don't realize is that the Wolfenden report was also about heterosexual sex work. Its proper title was The Report of the Departmental Government on Homosexual Offenses and Prostitution. Given the important events that had developed since the 1977 Supreme Court of Canada case, in which the court effectively gutted the soliciting law around street-based sex work, I believe Trudeau Sr. wanted a Canadian study. In June of 1983, he commissioned the Special Committee on Prostitution and Pornography, or better known as the Fraser Committee. The committee held hearings in 22 cities from January to June 1984. While very far from perfect, the report recommended the federal government partly decriminalize sex work. They suggested implementing a tougher law to deal with street-based sex work, but recognized that it was illogical to leave us with no place to work at all. So they proposed that the body house law be liberalized to allow up to 2 sex workers to work together out of their own residences. Insofar as licensing us, the Fraser Committee recommended that it merely be licensed and zoned like any other business. The committee also recommended the repeal of the procuring offenses and the offense of living on the avails of prostitution. They would be replaced by a much more limited section that would deal only with procuring accomplished by use of force, threats, or coercive or threatening behavior. Another new offense would cover inducing a person through threats or coercion to support one financially through prostitution. The Fraser Committee report was released in April of 1985, and for its day, it was progressive. I think it would have been a good beginning on the road to full decriminalization. But alas, Trudeau Sr. decided to retire and left office in June of 1984. 3 months later, Brian Mulroney of the Progressive Conservative Party became Prime Minister, and we were left out in the cold again. Instead of liberalizing the body house and procuring laws, Mulroney simply enacted a new and heavy-handed law to criminalize street-based sex work. So with the exception of that glimmer of hope from Pierre Trudeau, the 3 main political parties have always looked upon the issue of sex workers like this. The NDP views us as victims. The Conservative, despite their recent victim rhetoric, continue to see us as villains. and the liberals ignore us as much as possible. Our patience ran out, and in the autumn of 2006, we began preparing a charter challenge to the anti-sex work laws that were causing us the most harm. Sex Professionals of Canada, or SPOC, formerly known as the Canadian Organization for the Rights of Prostitutes, had wanted to challenge the law since we formed as a group in 1983. By 2005, we could see that the tide was turning in the way the average person viewed sex work. Many, if not most people, thought our occupation should be decriminalized or legalized. Most people weren't clear on the differences. However, the most compelling reason for SPOC was that the laws were causing our colleagues catastrophic harm. The number of sex workers who were being raped, robbed, beaten, and murdered was at an all-time high. The effect of the communicating law introduced by Brian Mulroney's Conservatives was to force our street-based colleagues to work in isolation and in dark alleyways. That, combined with police indifference when sex workers went missing, was to tell predators that it is fine, almost desirable even, to do whatever they wanted to us. While the federal government was unwilling to talk with us, we had no alternative but to seek justice via the courts. It is important to know that while all of this horror was happening, the vast majority of actual clients were and continue to be good and gentle people. I do not want to give you the impression that sex workers routinely experience violence in our daily work lives, and I am pleased to report that we now have Canadian empirical evidence attesting to this fact. So originally, we were only going to challenge the body house and living on the avails provisions. And in a legal challengey sort of way, that made sense because the two laws went hand in hand with each other. For example, most people believed that a body house consisted of several sex workers and a madame. In fact, most body houses were comprised of one sex worker working alone out of her own apartment. If she lived with a roommate or a significant other, that person was vulnerable to being charged with living on the avails. It rarely mattered if that person had employment elsewhere. Even two women working together for safety and sharing of the expenses of the rent, phones, internet, and advertising, which is one of the ways I worked for years, could easily be charged with living on each other's avails. It was also risky for us to save money to buy a house or invest in RRSPs or any other kind of legal investments. This was because both body house and the avails laws fell under the organized crime section of the criminal code. For body house, if 3 or more sex workers shared a location, the organized crime law kicked in. In those cases, bank accounts were frozen along with any legal savings. The police could and did show up with moving vans. You were lucky if they let you keep your coat. If you were found guilty, everything you owned was forfeited to the Crown. If there were only 2 of you working and you were charged with living on each other's avails, then all of the above pertaining to organized crime applied. The avails law was introduced ostensibly to protect us from big bad pimps. But there were already many laws on the books that could and still can protect us from exploitive people. Laws like assault, extortion, forcible confinement. So why a law that made it illegal to work with anyone? The laws forced us to work alone, in secret, and untraceably. But I was never comfortable with leaving my street-based colleagues out of the equation of our charter challenge. When Spock's Amy Lebovitch joined the case as a plaintiff, she was adamant that the communicating law be challenged. Other sex workers' rights groups across the country insisted the communicating be challenged as well, and we included it, and I'm glad we did. After some back and forth with legal aid, we managed to receive $32,000 to help fund the case. $32,000 was far short of the $500,000 plus that were needed for a case like this. But Professor Alan Young, our lawyer, was doing this pro bono, and the legal aid money meant we had enough to cover some of the court filing fees and fly some of our academic or expert witnesses in and put them up in a hotel for a night. Some of our experts lived in Toronto, others stayed with family or friends, and a couple of them even paid their own way. There was a lot of goodwill from the academic community in seeing this case through. So I will now explain the reasons why we used the arguments that we did. Our challenge was based on life, liberty, and security of person, Section 7 of the Charter. The evidence that we had supported our challenge on the basis of Section 7, but not on the basis of equality arguments. Given the horrific violence and the murders of our colleagues, it made sense to fight the laws on the basis of life, liberty, and security of person. These were laws that forced us to choose between our liberty and our safety. When we filed the case in March of 2007, faith-based organizations were still finding their feet regarding the issue of sex work. But once the evangelicals made sex trafficking their pet cause around 2005, 2006, publicity and money began coming their way. The anti-sex work or radical feminists noticed, and they got on board with that too. At first, they were talking about the trafficking in people across borders for the purposes of forced sexual labor, or as they later called it, sexual slavery. The media and general population loved this story about women being chained to beds and forced to have sex. Quite a number of faith-based organizations put up websites using models depicting those images. The Salvation Army was one of the worst offenders. About 2009, lurid movies of the week portraying sex trafficking played on network television channels. By 2010, faith-based and radical feminist organizations, which we call prohibitionists, were pulling in vast sums in grants and donations. But it was becoming clear that there weren't that many of these so-called sex slaves to be found. So they slightly changed their definition of trafficking. They labeled all sex workers as trafficked persons. Their reasoning was that we could not see the damage sex work was doing to us. Therefore, if a woman, they barely mentioned male or transgendered sex workers, was putting in her own ad, booking her own calls, and not sharing her earnings with anyone, she was trafficked. Once all of us were counted as trafficked, their statistics looked really good. When sex workers protested this overt mischaracterization, we were told that we lacked the ability to understand because we were all suffering from post-traumatic stress disorder. However, the media was not informed of their new definition of human trafficking. I remember reporters being surprised when I would tell them. But no matter, media still parroted the drivel from these orgs, because why let facts get in the way of a good sex story? So, what you need to know is that in 1990, the Supreme Court of Canada, in a reference, upheld the bawdy house and communicating laws on the basis of preventing nuisance. This meant for our case, pardon me, to go through, we had to get through the principle of stare decisis. Stare decisis is Latin for let the decision stand. In essence, it means that once a court has answered a question, the same question in other cases must elicit the same response from the same court or lower courts in that jurisdiction. Unless there is new and compelling evidence, lower courts are loath to overrule a higher court, and the Supreme Court of Canada doesn't like to change a ruling about laws it has previously ruled on. The evidence we had for Section 7 was compelling, unavailable in 1990, and voluminous. A lot of it was about the detrimental effects the laws had on our safety. Even then, it was a tough slog to get through stare decisis. At least I think it was. Maggie's and Power, two sex worker rights-led organizations, tried to intervene using equality arguments, but the Supreme Court refused to hear them because at that level, arguments using a different section of the Charter are not permitted. Still, Maggie's and Power's arguments were good, and I do wish the court would have heard them. I would have liked to have seen life, liberty, and security of person interpreted through the lens of equality. But courts are like anyone else, and they don't want to do extra work. They can pick and choose how they will rule, what laws they will rule on. For example, we shall also invoke Section 2B. The lower court ruled on that. It was in our favor, but the Supreme Court simply refused to rule on it. So at the beginning of the case, our first stop on the road was at the Ontario Superior Court of Justice. Even though we filed our application in March of 2007, by the spring of 2008, a judge had not yet been assigned to hear our case. That was okay, though. It was decided to hold the witness testimony and cross-examinations in the boardrooms of the Ontario Regional Office of the Department of Justice downtown. While everything was under oath and every word was recorded and is available as a matter of public record, the boardrooms were not open to the press or the public. This took some pressure off everyone, especially the sex worker witnesses. It was also easier for scheduling our other witnesses. I was first out of the gate to be cross-examined. Two senior crowns from the Attorney General of Canada's office, Michael Morris and Gail St. Clair, were assigned to our case. They had several assisting crowns. I had the impression that Michael Morris truly loathed sex workers, and while good at her job, I did not get that sense from Gail Sinclair. The Attorney General for Ontario also decided to fight our case, and that was Ms. Shelley Hallett. She was incredibly rude, just insane. But from the outset of our case, Real Women of Canada, the Christian Legal Fellowship, and the Catholic Civil Defense League formed a coalition and were literally on our case as friends of the court. A friend of the court is a group or person who is not asked to be part of the case, but believes they have information that bears on it. Their factum, or written submissions, stated, Canada is a moral country. The charter was drafted by people who held religious views for the benefit of persons who held religious views. These religious views form the backbone of what can be identified as societal values of Canada. The prohibition on certain activities related to prostitution is a rational means of safeguarding Canadians' values on the basis of a fundamental concept of morality. Prostitution is considered immoral and dishonorable to both participants and God. The lawmakers' view of the prostitute as both a moral and legal outcast influenced the law and its enforcement throughout the 20th century. The interveners, meaning them, submit that prostitution is immoral. It should be stigmatized. Back in 1996, on Victoria Day in downtown Toronto, a predator shot 3 sex workers at point-blank range within a 2-hour period. Everyone thought it was fireworks going off. When arrested, he said he was, quote, getting rid of the street scum, unquote. In his defense, his mother said he was, quote, getting rid of the garbage on the street, unquote. You just wonder where people get those ideas. We had 21 witnesses comprised of 11 sex workers and former sex workers, 1 MP, Libby Davies, 2 journalists, and 8 expert witnesses. I don't recall the exact numbers for the Crowns, but most of their academic witnesses were from the United States. Our case had a statistician. He went through all of the studies of both our experts and the Crown's. There were no significant problems with our experts' research. There were significant problems with some of the Crown's experts. The Crown's central argument was that there was no connection or causal link to the harm suffered by sex workers and the laws we challenged. They stated that prostitution is an inherently dangerous and harmful activity, both to those directly engaged in it and to society at large. That inherent risk of harm is demonstrated to exist regardless of the many ways in which prostitution is practiced, whether street or off-street, and regardless of the legal regime in place. We had reams of evidence that countered that. So the Crown spent an awful lot of time talking about human trafficking and child exploitation, even though we did not challenge any of those laws. Several of the Crown's academic, and I use that term loosely, witnesses insisted that the average age of entry into sex work, or prostitution as they call it, is 14 years old. I'm sure you've all heard that statistic. Studies that were and continue to be relied upon are Susan McIntyre's 1999 Calgary study. One of the problems with that study is that all of her 50 research subjects were youth. Another study often cited is Estes and Weiner's University of Pennsylvania Commercial Sexual Exploitation of Children in the U.S., Canada, and Mexico. That study also excluded adult sex workers. And even though its title states U.S., Canada, and Mexico, no research in that study was conducted on anyone in Canada. None whatsoever. But the prohibitionist researchers had been getting away with wildly extrapolating and misrepresenting their statistics for so long in the media that they seem to think they could surely do so in Canadian courts. In terms of that often quoted statistic of 14 years old, our experts who did real research found that most sex workers in Canada began at 19.7 years of age. I'm not going to stand here and tell you that no one ever began sex work at 14, but I will tell you that it is unusual. And I've been in this business for a long time. And the usual ages are between 18 to 24. So the Crown's star witness was Dr. Melissa Farley from California. There are a lot of problems with her research, but I won't go into them all because we'll be here all day long. Farley goes further than many prohibitionists, and when conducting a study in New Zealand, she stated on New Zealand television that she had evidence that girls as young as 9 were entering prostitution. However, her research assistant, Colleen Wynn, couldn't take the BS any longer, and she wrote a formal complaint to the California Board of Psychology that Farley had fabricated and misrepresented data in elements of reports which Farley had prepared on prostitution in New Zealand. Among Wynn's accusations was that Farley alleged statements that she had evidence that girls were entering prostitution at 9 and that was untrue. The studies she performed did not collect any data indicating this. According to Wynn, Farley was operating her research project without an oversight from an ethics committee in New Zealand. And I quote from Colleen Wynn, "I have read and am aware of the ethics of psychologists working in New Zealand. I know these were not adhered to," unquote. Wynn also stated the study was not ethical and the impact has done harm to those women and men who took part in it. "I also believe that Melissa has committed an act of intentional misrepresentation of fact." 16 scholars have also made formal complaints against Farley's methods concerning a study she did in Scotland. And our application judge at first level of court, Susan Himmel, stated in her ruling on our case, "I found the evidence of Dr. Melissa Farley to be problematic. Although Dr. Farley has conducted a great deal of research on prostitution, her advocacy appears to have permeated her opinions. For example, Dr. Farley's unqualified assertion in her affidavit that prostitution is inherently violent appears to contradict her own findings that prostitutes who work from indoor locations generally experience less violence. Furthermore, in her affidavit, she failed to qualify her own opinion regarding the causal relationship between post-traumatic stress disorder and prostitution, namely that it could be caused by events unrelated to prostitution." And our judge went on. So at the end of all of it, she said, "Accordingly, I assign less weight to Dr. Farley's evidence." Well, yes, Dr. Farley makes stuff up. And her own opinions contaminated her research. Personally, I think that what's important is not whether the researcher is a lifelong advocate of sex workers' rights, or if the researcher thinks we're all mindless victims in need of immediate and forcible rescue. What matters is that the studies be conducted properly and meet scientific criteria. That's when you can really learn. And I think that that is what studies ought to be about, learning. Another Crown witness, Dr. Janice Raymond, used statistics she read in a New York Times article as evidence to support her position in her well-known article, 10 Reasons for Not Supporting Legalization of Prostitution. All real studies, they say, she stated that the reasons why were because legalization of sex work expands the industry. But all real studies state the opposite, including the government of New Zealand's Prostitution Law Reform Committee. And New Zealand decriminalized sex work across the board in 2003. So they have a lot of good evidence. No matter that the person quoted in the New York Times article stated in the article that he wasn't really sure if legalization expanded the industry, Dr. Raymond just morphed that into a supposed fact. I don't understand why any researcher would even use an article like that as a source. So our application judge, Susan Himmel, waded through the 25,000 pages of evidence and released her judgment on September 28, 2010. She agreed with us. We were stunned. At Sex Professionals of Canada, we had written 4 different press releases, but didn't bother to write one in case we won everything because we were certain we would not. I mean, we're used to never winning anything. We're used to systematic state oppression. And here we have a court, an agent of the state, if you will, agreeing with us. So it was wild. The taste and feel of this potential freedom was entirely new. We held a press conference at the 519 Community Center on Church Street. The room was filled with wall-to-wall reporters and cameras. It was the first time I ever saw Professor Alan Young semi-speechless. We answered questions to the best of our ability, considering that we were in a state of shock. Toward the end of the press conference, people asked where the victory party would be held that evening. But we hadn't contemplated holding a victory party. In the ensuing weeks, there was much press. The decision really woke up the religious fundamentalists and the prohibitionist feminists. They were appalled, and they called for Judge Susan Himmel's removal from the bench. Talk radio, including CBC's cross-country checkup program, a call-in show, had every prohibitionist they could find slamming Judge Himmel and us. Though we fought them in the media, Canadian sex workers needed to be as well-funded and organized as these two large groups of people. We weren't. Nor did we have the ear of the conservative government, whereas they did. Instead of contacting us and beginning the process of decriminalization, the day after Judge Himmel's decision, Ontario and Canada announced they would appeal. So we were off to the Court of Appeal for the second round. Ontario Appeals Court is notoriously conservative. Typically at this level, 3 justices would have heard our case, but strangely there were 5. And I have a feeling that that had something to do with Stephen Harper and Peter MacKay. We didn't care. We said, bring 21. Our case is solid. So the arguments were heard in June of 2011, and we knew this was too soon. But once a charter challenge is launched, it is not up to the plaintiffs or their legal counsel in terms of dealing with its pace. It's up to the courts. They determine the pace the case will go. So Canada and Ontario continued with their mishmash of morality arguments, dressed up as, on one hand, viewing us as victims, and on the other as agents of our own misfortune, and that it was not up to Canada to help prostitutes work safely. These are recycled Morgan-Tyler arguments. No, it wasn't the laws against abortion that caused women to seek out back alley abortionists. Those women of loose morals did that of their own accord. Canada talked about how violence against us was proof that sex work is inherently dangerous, and insisted the laws were not the cause of the violence. It was those evil Johns and pimps. Canada tried to introduce new evidence, which is not permitted for either party at that point. Their new evidence consisted of a report by a street outreach worker from a religious organization. The report claimed this person met with anonymous guys on the street and in cafes who supposedly said they would like to become pimps. That report was not permitted. But I remember Alan having to really fight it. The Crown kept talking about children and pimps to the point where one of the justices became visibly annoyed. Keep in mind that we did not challenge any of the child exploitation or trafficking laws. One of the justices asked the senior Crown, in what other legal occupation is a worker not permitted to take security precautions? The Crown replied, drug dealing. I'm not making this up. The justice said, that's not a legal occupation. The Crown then said, ingesting drugs. The justice said, that's not an occupation. At that point, I almost felt kind of bad for him. Then he droned on about inherent violence in prostitution, always ignoring the fact that the laws were the problem. So that round of court was a real circus. This time the prohibitionists were ready to fight this case in the court of public opinion. They and their former sex workers, now professional victims, were out in force and all over the media. They ran with the trafficked, underage, and victim rhetoric. I found it a very, very tough 4 days. Many groups, both for and against us, had sought intervener status. When you get up to appeals court, lots of people want to intervene. So interveners for us were the Canadian Civil Liberties Association, PACE, a sex worker rights organization in Vancouver, Downtown East Side Sex Workers United Against Violence Society, Vancouver, Pivot Legal Society, Canadian HIV/AIDS Legal Network, British Columbia Centre for Excellence in HIV/AIDS, British Columbia Civil Liberties Association, and a sex worker rights group in Ottawa, POWER. Interveners against us were the Canadian Association of Sexual Assault Centres, the Native Women's Association of Canada, Canadian Association of Elizabeth Fry Societies, 4 groups from Quebec with very long French names, and the Vancouver Rape Relief Society, or as they preferred to be called for our case, the Women's Coalition for the Abolition of Prostitution. There wasn't enough seating in the courtroom itself because of all of the interveners' lawyers and some of the press. So there was an overflow room set up with video of the proceedings. And that's where most of the sex workers sat. I think that's where most of the interveners' lawyers should have been. I remember reading an article about how the sex workers in the overflow room were very respectful, even standing when the justices entered and left the actual courtroom. I was not surprised by that. On March 26, 2012, the Court of Appeal released its ruling. Now that is a pretty conservative court. The ruling did strike down the body house law. They upheld the communicating law on the basis that it did not infringe on our right to life, liberty, and security of person, and was justified in a free and democratic society. And they read down or altered the procuring law to say that it would not apply except in circumstances of exploitation. No one knew exactly what circumstances of exploitation meant. So all we really won, though still it was a big win, was body house and to a certain extent living on the Vales, and only in the province of Ontario. Being a party to launch an appeal, because we're thinking of the Supreme Court now, is a logistical and administrative nightmare, to quote Professor Alan Young. So we were hoping the feds would launch the appeal. The Harper government, being what it was, couldn't stand the idea of sex workers being able to work indoors with each other for safety in Ontario. The specter of nice brothels being set up unnerved them. You know, bylaws and things like signage laws and all of that would have come into play in municipalities. But no matter, a few days later, the feds launched an appeal to the Supreme Court of Canada. We, of course, rose to that occasion, and there were several appeals and cross appeals flying back and forth. There was the usual gang of interveners, with a few more added: the Evangelical Fellowship of Canada, the Attorney General of Quebec. Ontario didn't intervene at the Supreme Court level. The Asian Women Coalition for Ending Prostitution. New interveners for us were the David Asper Center for Constitutional Rights, the Institut Simone de Beauvoir, and Aboriginal Legal Services of Toronto. So the Supreme Court heard arguments in June of 2013 over a period of 2 days. Stella Group, a sex worker-led organization from Montreal, and Power managed to obtain some funding and brought in sex workers from all over the country. The plaza in front of the Supreme Court was a sea of red umbrellas. It was great. Everybody was there. You know, people you hadn't seen in years, and everyone was happy to be there. It was warm. It was lovely. So 6 months later, on December 20th, 2013, the court released its decision. That was very fast. 6 months? We were sure it meant that we had lost. But we won. Again, we were stunned. They did put a 12-month stay on the decision to give Parliament time to either choose to let the laws fall and remove them from the criminal code or write new laws. But the court stated at paragraph 136, Parliament has the power to regulate against nuisances, but not at the cost of the health, safety, and lives of prostitutes. In effect, the court declared that sex workers were deserving of the same rights and responsibilities as all other Canadians. that taste of freedom was in the air again. And it was wonderful for about 3 weeks. Yeah. The well-funded religious fundamentalists and prolific anti-sex work feminists were livid and began an all-out campaign against sex work in the court of public opinion. I have never read so many op-ed pieces, news articles, watched television interviews conflating sex work, or prostitution, as they call it, with human trafficking of women and children in my life. And I just spent almost 7 years battling these people in court. The internet was full of it. I could barely open my computer without it streaming in my face. Across the nation, the evils of prostitution sermons thundered from the pulpits. Churches had posters on their websites and sample letters to the federal government that their members signed. Sex worker rights groups, with our meager to non-existent funding, did the best we could by writing articles, doing media interviews, holding marches and events. Interveners who were on our side helped, but together we couldn't stop the avalanche of hatred. The bogus studies, the ones the court found did not meet scientific criteria, were trotted out in the media as the gold standard. A few weeks after the court ruling, the police began a national campaign of harassment against sex workers. It is called Operation Northern Spotlight, to save us. Police trolled our ads, posed as clients, and made appointments for a specific time. If you were working in call or from your home, and you opened the door to find 3 or 4 cops standing there. If you were doing out call, you open the cop opens the door to the hotel room and you find 3 or 4 cops sitting there. They demand your ID, and most sex workers comply because you're freaked out. And if you're doing in-call, now they are in your apartment and they're asking you very personal and invasive questions about your life to determine whether or not you are a victim of human trafficking. Sometimes they look around your apartment. Sex workers were often too fearful to say, "Hey, unless you're here to arrest me, go away." The police stated Operation Northern Spotlight was to build a relationship of trust with us. Yes, lying and intimidation are real building blocks for trust. Operation Northern Spotlight still happens because it is still funded. The religious right and the anti-sex work feminists had the sympathies of the Stephen Harper government. I have since learned that the religious groups anticipated our win and had already submitted 2 policy briefs to the federal government prior to the Supreme Court's ruling. If they hurried, they could rewrite the laws and get them through before the 2015 general election. During the summer of 2014, they rushed through the parliamentary and Senate committee hearings. On December 6, 2014, almost 1 year after the Supreme Court's ruling, the Orwellian-named Protection of Communities and Exploited Persons Act became law. The Harper government didn't care that the new laws were even worse for us than the old laws. They knew we would have to fight them differently than the old laws, and we would need years to amass evidence. PSEPA, as we call it, is a set of inconsistent and incoherent laws. Adult sex workers are deemed to be incapable of giving consent. lacking in human agency with no ability to make autonomous choices. PSEPA has a preamble in it, which is a new fad in drafting laws. It's not part of the legislation itself, but acts as a guideline to judges. In respect to PSEPA, it also acts as pure legal moralism. Legal moralism is when an act is considered immoral, but it does not have to do harm. Consensual adult gay and lesbian sex used to be illegal on a legal moralism basis. Now it is consensual adult sex involving money or gifts. PSEPA is contradictory in that it allows us to set up small-scale brothels because they did not bring back the body house law. That's the one law they didn't bring back. Hire security or a receptionist, and sort of, possibly, maybe advertise. But whoops, our clients can face a prison term of up to 5 years for seeing us under any circumstances. Talk about sending mixed messages. As Professor Alan Young said, only in the legal world of Alice in Wonderland could a government allow someone to set up a small-scale business legally, advertise his or her services, and then punish those who respond to the invitation to hire the service provider. PSEPA effectively legalizes entrapment. The advertising section is murky because the owner of a website or a newspaper must ensure that every sex worker's ad must be put in by that sex worker and only for that sex worker. And even then, they can be charged. Many sex workers work together sometimes, and lots of us do duos. In social media advertising, we like to post that fact. It really works well. But if we do, we can be charged under the advertising section and possibly under the new living on the avail section, which is now called material benefits. Clients are still seeing us, but they don't want to give us their legal names, fearing we are the police doing a sting. Most sex workers' ads used to stipulate no blocked calls. Not anymore. So we don't know who we are seeing. Of course, this serves us up on a silver platter to sexual predators pretending to be clients. In 2017 alone, 11 sex workers that we are aware of have been murdered in this country because PSEPA ensures that we must work alone, in secret, and untraceably. So once again, we are amassing evidence. But the Harper government was clever and crafty in drafting PSEPA because the law no longer plays a causal role in our security of person impairment. Because we can work indoors in a brothel, because we can hire a receptionist, but that's completely undercut when it's illegal for our clients to see us. Nevertheless, in a legal world sense, they're no longer responsible. The exception to that would be the communicating law, which was outright reintroduced. That could be fought on life, liberty, and security of person because it still forces us to work in very dangerous conditions and does impair our safety and security. It is interesting that Parliament has on paper given immunity to indoor workers while still uses criminal sanctions against the most vulnerable sex workers, our street-based colleagues. Never believe any rhetoric from the conservatives about how sex workers are victims. They firmly view us as disposable villains. We could challenge PSEPA because it's a new set of laws, so new arguments. We could challenge it with arguments on equality, freedom of expression, and Section 7 for communicating. And we might even win. But then what? By the time we got through the 3 court levels, 6 to 8 years down the road, a conservative government would likely be in power. And that would not work in our favor. I think that Andrew Scheer, who's the leader of the Conservative Party, I think he's just keeping the lights on for Peter MacKay, who is the architect of PSEPA. Our arguments were sound. It was the timing that killed the victory. If we could have delayed the final ruling by 1 year, it would have been very unlikely that Stephen Harper's conservatives would have had the time to write and pass new laws. If the final ruling had been delayed by 18 months, they definitely would not have been able to write and pass new laws. It would have ended up in Justin Trudeau's lap. So, shortly after our win, Trudeau stated that the Nordic model, which is what PSEPA is sort of based on, would be best because prostitution is violence against women. 3 months after our Supreme Court ruling, University of Ottawa and Carleton University put on a conference titled Sex Work After Bedford, Legal Reform in Canada. 13 speakers, most of them sex workers, including Catherine Healy, the longtime national coordinator for the Prostitutes Collective of New Zealand, spoke. A few days after the conference, I received a call from a Liberal senator's assistant. Turns out some of the Liberals heard that all of the sex workers warned against the Nordic/Swedish model and its criminalization of our clients. They were surprised. They had no idea. The senator wanted a copy of my talk, and I'm pretty sure other speakers were contacted as well. And this senator is a constitutional law expert. Joyal is his name. I was happy to send it to him on the understanding that it be kept out of the hands of the Conservatives. 3 months later, when the parliamentary committee hearings happened, many sex workers testified. It was really nice to see that, because it's difficult for sex workers to come out. But they felt that this was so important that many of them did. The Liberal MPs asked intelligent questions, and that told me that some of them likely did their own research. I've spoken at several parliamentary committee hearings, and I'm used to Conservatives being a bit rude, but this was something different. They practically jeered at sex workers who did not identify as victims. The Senate committee was a little more restrained. Again, the Liberal senators had done research and took down notes. Information that not all was well with the Nordic model, known as Bill C-36, then went back to Liberal Party leader Justin Trudeau. He spoke publicly against Bill C-36, and he and his party voted against it in Parliament. I watched the vote. They all came in and voted against it. Harper had a majority government, so Bill C-36 passed. But it does demonstrate to me that Justin Trudeau is at least willing to learn. Now, if he and his justice minister would stop ignoring us and repeal even just the most harmful sections of PSEPA, that would be most welcome. But, while we're all making plans, life happens. And last week in London, Ontario, a challenge to PASIPA began. 2 people who operated an escort service were charged with 29 offenses. The police just love to load them all up so that they could then plea bargain you down. But these people said no. And this will likely end up being a constitutional case. I'm not sure what arguments they will be using, but I'm pretty sure it'll be equality, freedom of expression. I'm not sure if they'll use Section 7. But I'm glad the defendants, Hamad Anwar and Tiffany Harvey, are putting everything they have into fighting this. You know, when it comes to consensual adult sex, you can only push people so far before they'll begin fighting back. And the sex worker rights movement is now a global movement. There are sex worker rights groups in Darfur. There are sex worker rights groups in Middle Eastern countries where you think, nope, that wouldn't happen, but they're there. So it's everywhere. The government of South Africa a couple of months ago stated that it wants to decriminalize adult sex work. And they stated that they're looking at the New Zealand model, which isn't a bad model. So we'll see what happens. And that is the very abridged version of Canada v. Bedford, Lebovitch and Scott.